So today with us, we are very proud to have Mr. Ilija Mitrev Penushliski, who is counsel for Three Crowns in Paris. He has represented clients in international arbitrations conducted under all major arbitration rules, focused on complex investment and commercial arbitrations, particularly in the energy sector. Dr. Kina Baltak, she's an associate professor in international arbitration at Stockholm University and a qualified attorney at law since 2004 with extensive practice in international commercial and investment arbitration, international dispute resolution, and private and public international law. Ms. Anna Stanic, she's an English solicitor advocate and Irish solicitor with over 25 years of experience advising states, companies, and international institutions on energy law, EU law, and international law with a specific emphasis on dispute resolution. And finally, last but not least, Mr. Philip Boras, a partner with Baker McKenzie and head of dispute resolution practice in the Vienna office. He is double qualified as an attorney in Austria and New York, representing clients in international arbitration proceedings before all major institutions and also in ad hoc arbitrations. This was only in order of their presentations, so no special preference or treatment. We are very delighted to have all of our panelists with us here today. But we would start the conversation by giving more background about how we got in this situation in the first place. So I would kindly ask Mr. Ilija to explain to us what is the source of the backlash against the Energy Charter Treaty? Was it disputes? Was it some political issues? And if there were some particular disputes that led to this kind of reaction, we'd be very happy to hear from you, from your experience.
Thank you. Dobar dan. I'm very excited to be here today among this impressive roster of speakers, and also because of the topic, but also because it's the first time I'm in Sarajevo. And I always get a warm feeling when I visit this part of the world, and when I travel to ex-Yugoslavia, the country I was born in. Thank you to Fahira, and to Armela, and to ARBITRI, and to Giz for the invitation. Now, stepping back from nostalgia and getting to literal warm feelings, energy. It falls upon me today to set the scene for today's discussion, especially for the first panel, but I hope also for the subsequent ones, and how we arrived at a moment that's been labeled by some as the slow and painful death of the Energy Charter Treaty. If Fahira gave you a presentation of the ECT, if you will indulge me a few more words about this treaty, once hailed as the most important multilateral instrument in energy cooperation. It's a well-known story of optimism that arose from the rubbles of communism. And it was conceived by the Dutch Prime Minister Ruud Lubbers as an idea trying to single-handedly resolve the principal energy concerns of the East and the West. And those were, in short, the so-called West needed security of supply, the so-called East required capital and know-how to refurbish and jumpstart energy production units that were failing. The West worried about investing in the East where judicial protection, where functioning judiciary and protection of property were largely aspirational. And the East was concerned that it would not be able to materialize these aspirations into true reform in time to attract capital. So the solution was the ECT. It took nearly 4 years to negotiate. When I worked on the Yukos arbitrations, I scoured through the travaux préparatoires of the ECT in the vaults of the Energy Secretariat in Brussels. And it was fascinating to see how the sausage was made by experts and diplomats. Now back to the story. By any measure, the result of the negotiations was a real success. A promise of energy cooperation in Europe and beyond. A treaty that regulated energy, investment, trade, transit, and efficiency. a treaty that applied to the economic activities in the energy sector, something that was broadly defined to include most energy carriers of that day, including renewable electricity produced from renewable sources. Now, the ECT has had 53, I believe, signatories. Some, notably Russia, did not ratify it, but applied it provisionally until 2009, when it decided to not become a party of the ECT. But it was not just Europe and Russia that signed up to this treaty. Central Asia and Japan also were signatories. So that's in 1994. Today, as Fahira mentioned, we seem to be at the beginning of an exodus from the ECT. This year, well, Italy left the ECT in 2016, and this year 6 other countries have announced their departure from the ECT. This includes the original champion of the ECT, the Netherlands. The vote on the proposed modernization of the ECT, which was supposed to take place yesterday, was postponed until next year, but perhaps indefinitely. At the screen, I have set out a timeline that shows one more. There you go. That shows the beginnings. And if you click further, can I control that or no? Can I control, do you have a clicker?
There.
No? Okay, that's fine. Okay, that's okay. And you can see the beginning and the present. So, signed in 94, preceded by the European Energy Charter in 91, and you have in 2016 and 2022 the exit of 7 states.
Okay.
What happened in the meantime, and why are states leaving? Well, the first thing to observe is perhaps something that's quite obvious, and that is the number of cases that we've seen over the years. And as you can see on the slide, I've overlaid on the timeline the number of cases since 2000 and onwards. Most of these were commenced in the early 2010s, mid-2010s, and with the average duration of an investment arbitration of 4 years, most of them yielded results towards the end of the last decade. So these 150 ECT cases gave plenty of material for states to react to the ECT, but also for observers to hatch theories about the ECT and what's wrong with it and what's not wrong with it. I have selected what I think are 4 clusters of ECT-related cases that I believe are very important for our understanding of what affected the political position regarding the ECT. So, to begin with, in chronological order, beginning in 2007, Hungary was the respondent in 3 arbitrations launched by European investors concerning the termination of long-term power purchase agreements. Now, in the arbitrations, Hungary was claiming that what it was doing, the termination of the PPAs, was based on its efforts to implement European law in respect of state aid. The European Commission intervened as an amicus in all 3 cases. Hungary won 2 of those and lost 1. And a side marketing point, I was involved in the team that helped the one investor prevail. But the point is this: through these cases, the European Commission learned that an investment tribunal can examine EU law, including competition and state aid law, and that a state may be found liable even if it argues that what it was doing is complying with EU law. And this matters became worse at the time when the Mikula arbitration was commenced, and as we all know, that It's not an ECT case, but it was. It further inflamed the European Commission in its crusade against investment arbitration. That led to ACMEA and the termination of intra-EU bids. Now, the second chronologically important matter is Vattenfall suing Germany for the phasing of nuclear power. In 2011, Germany, which we all know is a significant capital exporter, found itself as a respondent in an arbitration because of this phase out of nuclear power generation. Vattenfall, which is also a European Swedish company, argued that the shutdown infringed upon its rights under international law and sought compensation from the ECT. And so Germany, its politicians, and the NGO sector were in uproar because, as everyone was saying, Germany was pursuing public policies that were the result of the fallout from Fukushima, and that it was strange that a private tribunal could sit in judgment of such policies. Now, this comment ignores one important thing, which is that the Constitutional Court of Germany itself twice held that insofar as the amendment of the law on nuclear power did not provide for compensation to nuclear operators, then this was contrary to German constitutional law. A third group of matters, and perhaps the most influential ones, are the flurry of arbitrations against Spain and Italy, a total of 64 cases today and counting, in respect of modifications of legislation regarding electricity produced by solar panels. The investors argued that the two states lured their investments through promises about feed-in tariffs regarding renewable production of electricity, but then went on to modify or even entirely withdraw those promises. Many arbitral tribunals agreed with the investors and ordered Spain and Italy to pay substantial damages to green investors. Fourth, and this is very recent, Uniper and RWE, German companies, launched two arbitrations against the Netherlands for the Dutch government's efforts to phase out coal. Now, it seems pretty egregious for investors to be suing a government for phasing out coal in current circumstances, but I think that the situation is far more nuanced if one looks at when these investments were made and on what kind of encouragement from the Dutch government they were made. In fact, these plants came on stream very recently. So their lifetime is only at the beginning, and one could argue that the investment that was made, that was substantial, had not been recouped at all. Fourth, and so against that background, in 2006, you have these four sets of cases that all involve very sensitive issues: intra-EU disputes, public policies seeking to phase out certain types of electricity, policies regarding the attraction of renewable energy. Against this background, in 2017, the member states of the Energy Charter commenced a modernization process that involved 16 rounds of negotiations and produced a draft treaty that was draft amendments of the treaty that was leaked in June 2022. And one of the key discussions that was had between the parties was to phase out fossil fuel protection in the ECT. And the draft treaty that was leaked in June well envisaged phasing out of fossil fuel protection, excuse me. Now, last month, if we go to the next slide, last month, the European Commission itself hailed that draft as being consistent with the Paris Agreement's objectives, and that you have on the slide, and it's from 5th October 2022. Now, the vote on the ECT, as I mentioned, was supposed to take place yesterday. It didn't take place. Many states left the ECT in the meantime, since June, and these are the statements, the ones that you see on the screen, that I've been able to collate from the states, and they've offered explanations as to why they're leaving the ECT. And they fall broadly in two categories, if you'll permit me. One is that the ECT threatens the EU legal order, and the second is that the ECT is incompatible with the Paris Agreement and the fight for climate change. One wonders if matters are as simple as they are stated in these statements. My personal and humble assessment of the drivers behind what is happening is as follows. First, nobody likes being taken to court. The ECT has produced 150 cases, and although today the East-West dichotomy might no longer be as pertinent as in 1991, the so-called West is now facing just as many arbitrations as the so-called East, if not more. Perhaps avoiding arbitration is more important than having one's investors enjoy investment protection. Second, it is true that the European Commission does perceive investment arbitration as a threat to its supremacy in the European legal space. It has acted ferociously and effectively, and it has gotten states on that bandwagon. Third, and this is perhaps a side comment that I'm less qualified to make, but I'll venture and say that there appears to be a general retreat from the paradigms of Bretton Woods and the Washington Consensus that cross-border investment flows should be encouraged and protected. This seems to go hand in hand with the reactions to globalization. Fourth, and I suppose this is my key point and last point, the backlash against the ECT, to me, is prioritizing immediate publicity gains over real substantive advancement in both investment protection and pursuing the Paris Agreement objectives. Sure, leaving the so-called fossil fuel treaty is low-hanging fruit when it comes to marketing one's efforts to fight climate change. But here is the simple reality. First, and as you'll see in the last slide, and I assume most people know this already, the vast majority of cases under the ECT are renewables cases. They're not fossil fuel cases. And as I mentioned, the second point is that the modernized ECT envisaged phase out of fossil fuel protection. But, as I'm sure many of us here know, nicknames tend to stick. And the nickname of the ECT as a fossil fuel treaty has stuck. I don't believe it's crazy to say that the war on global warming is better served if a treaty encouraged investments in renewables and phased out coverage of fossil fuel investment, than if a treaty no longer protects any kind of investment, including investment in green energy. And lastly, I think the paradox of all of this is as follows. Under the ECT, under Article 47, if you exit the ECT, you are obliged to provide protection to existing investments for another 20 years. This includes protection to fossil fuel investments as well. But if you modernize the treaty, and agree to an early phase out of fossil fuel protection, you might be able to establish earlier end of fossil fuel protection under DCT. Thank you very much.